Welcome back. Judicial activism describes a judicial ruling that is suspected of being based on personal or political consideration rather than on existing law. Some say that this damages the rule of law, while defenders of the practice say that in many cases it's just a legitimate form of judicial review. Here to discuss legislating from the bench with me is attorney and former clerk for Supreme Court Justice Samuel Alito, when he was an appeals court judge, attorney Thomas Gentile, and Dave Pickney, Essex County resident and assembly candidate for District 28. Welcome and thank you for being here. I guess to start off, let's first explain what the difference is between judicial activism and judicial review.
The term judicial activism asks what the proper role of the judiciary is in our system of government. The Constitution, both the federal Constitution and the Constitution of the state of New Jersey, set forth three branches of government with distinct spheres of power. The proper role of the judiciary, according to the federal Constitution, is to review cases and controversies between people and parties to lawsuits. It is not the role of the judiciary to make policy. That is a role assigned to the legislature and to the executive, either the president or in New Jersey the governor, to put together the policies that they think are the best ideas for solving the problems that our society is facing at the time. Judicial activism refers to the idea that a judge or a court goes past their role of reviewing what the law says the proper outcome is in a litigation based on the fact of the case, and instead says, what does these individual judges believe is the best rule to be governing society based on their own policy preferences rather than what the law at the time says?
Thank you, Thomas. According to Judge Napolitano, he says that an activist judge is merely a judge whose ruling you disagree with. How do you feel about that, Dave?
Well, judicial activism, generally, I oppose to judicial activism because a lot of the judges go outside of what the Constitution stated that they're basically supposed to be a referee between the legislative branch, see if the legislative branch and the executive branch are going overboard. But sometimes judicial activism is actually a good thing, like the exclusionary rule that's supposed to be in the Fourth Amendment. Evidence is the exclusionary rule is written nowhere inside the Fourth Amendment. Yet the judges went outside of the parameters and they made new law saying that evidence cannot be used. Another case is in Miranda. In the Miranda case, the Fifth Amendment does not say that a defendant has a right to be told of their rights ahead of time. It's nowhere in the Fifth Amendment. Yet, in Miranda versus Arizona, the Supreme Court decided that a defendant does have a right. So sometimes judicial activism is good, especially throughout the civil rights movement. There was a lot of southern states that were just absolutely reprobate in actually enforcing the Constitution, and the judges had to go outside the parameters to actually make law to force the southern states to give blacks the right to the rights that they should have had.
Thomas, would you agree that there is a place for judicial activism?
I think it's important to be clear what we're talking about when we refer to judicial activism. In the examples you just gave from the civil rights era, when the governors and the legislatures and the police in the southern states were not obeying the law and the Constitution, federal courts that stepped in and said that they had to change what they were doing were in fact following the law themselves. Those courts looked at the law and said that the governments or the police were not following the law and stepped in. That's very different than a true case of judicial activism, which is when a judge decides to not necessarily give any regard to what the law says, but instead follow what that individual judge thinks is a good idea. That's the difference between judicial activism and other kinds of rulings.
Would you be able to give us an example of that misstep? That overstep, I should say.
I think we have two big examples of judicial activism and the judiciary overstepping its bounds right here in New Jersey. Those are the issues of low-income housing and school funding, which the New Jersey Supreme Court has addressed in two cases called Abbott and Mount Laurel. Abbott is the case that says that it is the responsibility of school districts across the state to raise the money to pay for education in low-income districts in New Jersey. And that has been imposed by the Supreme Court of New Jersey, and every budget that comes out of the New Jersey State Legislature regarding school funding has to be reviewed by the New Jersey Supreme Court to see if it complies with the Abbott doctrine. This doctrine has been a disaster for New Jersey for several reasons. First, the Supreme Court's approach basically amounts to throwing money at the problem, and it requires the legislature and the governor to direct money in the way that the Supreme Court says, and it handcuffs the governor and the legislature from taking real, innovative, creative, new solutions to actually solving the problem of our failing funding our failing schools, while their only concern is complying with these rulings from the Supreme Court. So it's not only that the Supreme Court happened to come up with an idea that was bad, it's also that the governor and the legislature are handcuffed from actually trying real new creative solutions.
But Tom, in our state constitution, it states that no money shall be drawn from the state treasury for appropriations made by law. Is that correct? Am I giving the correct?
And what we see with the institution of the Abbott decision from the Supreme Court is that the Supreme Court is effectively telling the legislature, you must allocate this money in this way, because in the view of the Supreme Court, there's another provision of the Constitution that doesn't say they have to do it, but the Supreme Court has interpreted them to say it has to do it.
So if we're going around the whole legislative process, it almost seems, why are we even bothering to vote for representatives if someone can come in and make their own law, almost?
Well,
Dave or Tom?
Absolutely. It's definitely usurping the power of the legislative branch, and that is definitely the court going outside of its purview. The court is designed to be a referee. It's not designed to legislate. Mm-hmm. And by jumping into legislation, the court is on a different cycle than the legislative branch. The legislative branch is a direct response from the people, and these are the people that are supposed to be making the laws. The courts are only supposed to be interpreting. When they go outside their purview, they are not equipped to deal with the minutia of the changing of the situation.
And this brings us to Prop 8 and what happened in California. I mean, the citizens of California had a public ballot, and they voted on their feelings and what they wanted regarding Prop 8. And it seemed a disgruntled voter did not like that and went to the courts to turn that around. Is it fair, once the people have spoken, to allow someone to come in and change a law? And, the public ballot is such a rare opportunity for the citizen to have a truly active role in their government.
Ruled by oligarchy.
So does it mean that if you don't like a law that's been passed, that you can just go to the court and say, I think this is unconstitutional, and take back what the citizen has already voted on?
Well, one of the problems with judicial activism, especially in New Jersey, is that courts have gone way too far in deciding what they think is unconstitutional or what they think is mandated by the Constitution. Of course, there are going to be instances in which a law is passed that flagrantly runs afoul of the Constitution, and in that case it is the proper role of the court to step in and strike it down. But that must be based only on the text of what the Constitution says, not on what individual judges think is a good idea and choose to read in to the Constitution on their own whim. One of the fundamental principles of separation of power is that legislators who are elected by the people are the ones who are in touch with what is happening in our communities, and they are the ones who know what the people want to be implemented in the legislature. I trust people like Dave, who have to knock on my door to talk to me, to get my vote, to be elected, to make decisions for what's best for New Jersey, than a handful of unelected judges who are not in touch with the people.
Now, speaking to that, Thomas, I mean, how much is it the fault of our legislators when they're defining a law? What is their responsibility to make sure that it does comply with the Constitution before it comes up for vote? Do they have a responsibility to do that?
Well, legislators, just like police officers and any other public officer in the state, do take an oath to be loyal to the Constitution of the state. And I think that legislators do have an obligation not to pass laws that they believe to be in violation of the Constitution. The question that comes up is if you have a distorted version of the Constitution that has been promulgated by judicial activist judges, can legislatures pass legislation or take other action to try to rein them in? And I think it is appropriate for them to do so because they're being true to the real Constitution when they do that.
Right, and you mentioned that our judges are appointed. In closing, do we see any chance of laws changing so that judges do have to be reelected or be elected?
I think there is a role for an elected judiciary. I think that when you travel to other states and you see how individual judges being up for election is actually a matter of public debate, and people take concern about it, and people care about who is elected to these judicial positions, you can see that there is some value in that. What needs to be avoided is the situation that you see in some other states, specifically across the river in New York, where they claim to have elections for judges, but it's really all controlled by backroom party politics.
And Dave, I'm going to give you the last word on judicial activism.
Well, the Constitution sets the United States a unique country, far apart from all the other countries of the planet, because in our country we are a nation of laws, not of people. If we were a nation of men or people, we would go back and forth, left, right, back and forth. But since we are a nation of laws, and all of us have to adhere to the same exact laws, I'm totally up for judicial. I'm against judicial activism altogether.
Thank you very much. I'd like to thank Thomas and Dave for being with us today. Thank you.